At the end. Good evening, sir.
Good evening, Mr. Romanus. How are you?
Oh, this is Damlola, sir.
Oh, okay, Adamilola, sorry. Báwo ni? How's your
Fine,
day?
sir. Fine, sir.
Thank God for everything. So, how many people are we expecting?
We are expecting at least up to 100.
Wow, I can see only 10 now.
Yeah.
So
So we
maybe we
just
give
more.
them some more time.
Normally, I like to start by 7, so that we know the people that's already. So we just start straight up. So I'll put the people now so they'll join.
Okay, fine. So
All right.
that means we give the that's in the next almost, let's say, 7, 8 minutes
Yes, sir.
by my time.
All right, sir.
Okay.
Yeah, good evening, everyone.
Good evening, sir. How are you, sir?
Well done, sir.
Yeah.
Yes, I hope you can hear me.
Yes, sir.
Yeah,
Yes,
thank
sir, we can hear you, sir.
Thank you very much. I can see is by my time is 2 minutes after 7. We are supposed to start 7 on the dot. What I can see here, we are seeing we are 52, right? Or minus mean, and we are just less than 50. So I think maybe before the end of today's class, we are going to get someone who will be our class governor. We have the class governor and deputy. I'm something like male and a female to be coordinating this class, because there are some things that you may want to get that through the lecturer, through us, so that the governor can coordinate that for more effective processes. So today is we are going to be having law related to security and investment. And I know this topic is not going to be for us just to pass our exam only. And this at the end of this today, tomorrow, and next tomorrow classes, I know some of us we are going to take some personal decision because of what we are going to learn from these classes. Because when we are going to talk about will, there are so many of us who have never talked about what the will is all about, how important it is to us as individuals, to family. Or when we talk about contracts, some of us, we have entered contract that we don't even know how we are tied and what kind of contract we're talking about. And I believe at the end of today's today, tomorrow, and next tomorrow's classes, we will be in a different person entirely as regard to will and contract and some other things that we are going to learn on this class. So, ladies and gentlemen, I think we can start. I can see we have a number of 16, which is okay, because some of us we have belonged for quite a while now. Instead of keeping us waiting, let's all just start and we wait for others to join us, see where the class is going. Good evening once again. And I want to use this opportunity to introduce our today's facilitator. This is someone who knows this subject in and out. He is an academia and also a practitioner. He's a lawyer. I also practice as a lawyer. Today, he's going to talk through this topic, law related to securities and investment. He is by name Barrister Joel.
My name is Adekola Olaiwola. Good evening, all.
Thank you very much, sir. I have the class, sir.
Hello. Good evening, everyone. Yeah, thank you very much, Mr. Romanus. It's a pleasure being with you. Can you hear me, everyone? Good evening, everyone.
Good evening,
Yes.
sir.
I can hear you, sir.
Yeah, it's a pleasure being with all of you. Yes, I always suggest that by the time we start, you need to mute your mics. Even if you have a question, you can always indicate by raising up your hand. But what I do is that it's always better for us to wait to the end of a particular topic. I'll take questions on that particular topic. We'll be able to exhaust that before we move on to a new topic. So we don't keep interpreting or interjecting ourselves all the while. We have today, tomorrow, next tomorrow. Like I said, my name is Adekola Olaiwola, is my first name. We are going to start as discussion. As I want to believe you can see my screen, I'm going to use the screen as a discussion point. But what I always say is this: everything I'm discussing with the class is the component of the material supplied by the institute. That's the material on law relating to securities and investment. It forms the basis of everything. Within these 3 days, we want to take a look at the content of the material. It is very bulky, but for the purpose of exams, we want to focus on those areas we know you actually need, not only to make you pass your exams, but even when you are in practice, eventually, majority of the topics we're going to discuss, we're going to see is very, very pertinent. to the practice as a stockbroker in whatever aspect you want to practice. Now we're going to start today by looking at sources of Nigerian law. The rationale for that is very simple. We want to discuss the laws we are using in Nigeria, which is what is being used to regulate the practice of stockbroking. When we talk of laws, I always say that we're looking at the set of rules that guides the behavior of people within a particular area. That is one simple definition. However, we are going to see as we move along that laws are divided into various components. But when we go to our topic for today, the first question we ask is this: the laws we are going to discuss, the laws we're using in Nigeria, where did we get them from? That's what we mean by sources. We are going to see that a lot of the laws that we are very conversant with are either religious aspects. That means that they have some religious background. You have laws that say thou shalt not kill. The holy books say that thou shalt not steal. By implication, if somebody commits the offense of stealing, murder, and so on and so forth, and that person is being punished, there's always a rationale for it. People say yes. Even the holy book says you must not steal, you must not kill. But what we want to look at here is the laws that regulates a lot of the business aspect of our lives in Nigeria. And we're going to see that when we discuss sources of law for this purpose, we break it into English law. We have Nigerian legislations. And the third and important one, which is for the purpose of our discussion, is judicial precedents, which I'm going to mention in passing. But we're going to see that almost all the topics we have in our syllabus here falls within the ambit of English law and Nigerian legislations. That's why when we get to any topic, I'll be able to tell you that this topic falls within the ambit of this. Now let's go to the first one, English law. The reason why English law is a component of Nigerian law is well known to everybody. Nigeria was a colony of Britain for about 100 years before we attained independence in 1960. As a result of this, a lot of the aspects of the British way of life was introduced into the country we call Nigeria today. Even the name Nigeria was coined by a Briton. Now we're going to see that the language you speak, just like I'm discussing with you now, is the English language, our form of governance and almost everything. By implication, our laws are not excluded. But when we say English law, we have a simple definition for it. The laws brought in by the British colonial masters, used in Nigeria, and which was retained in the country after independence. That's the general definition of what we call English law. However, we're going to see that what we refer to as laws of England or English law has three components. That means when the Britons were coming, they brought in a box, and this box contains the laws to be used in Nigeria and other colonies. But in that box, there are three sections. That means even there in England, they are recognized as being separate from one another. And these are what we call common law of England, doctrines of equity, and what we call statutes of general application. I will take that again. Common law of England. 2, doctrines of equity, which we refer to simply as equity. And thirdly, statutes of general application. Now, what we want to do this evening, for starters, is to break down the components. What is common law? What do we refer to as equity? And how do we recognize what we call the statutes of general application? Now, I want you to bear one thing in mind. They are laws we're using in Nigeria today. They are Nigerian law as far as we're concerned. The only thing is that we just want to go into the historical perspective. This law we're using, how did you come about it? That's why when we are moving, for example, we're dealing with contracts, I'll say at common law, you'll be able to know that there's a common law principle. When we are dealing with some other topics, I'll say equity provided this. You are going to realize that it's some of the laws brought in by the British colonial masters. And there are some of our topics that are actually statutes, which are brought in by the colonial masters that we refer to as statutes of general application. Now let's break it down. Common law is the law developed from what I refer to as the customs that applies to the various parts of England. To understand this, we go back to the history of England so many years back, centuries back. We are going to see that initially there was never a single country referred to as England, or by the other names they are called. It's called Great Britain. It's also called United Kingdoms. These are the names for that country. But I always say that about the most apt name for our discussion is UK. UK means United Kingdoms. That shows us the background of that country itself. We are going to see that as at the 4th century, there was never a single country. Rather, in that geographical area, there were different tribes having different customs and different languages inhabiting that area we refer to as UK or England today. This set of people were never one. They were always at war with one another. You have Scotland, you have Ireland, that's the Irish, you have the Welsh, that's the Welsh, and so on and so forth. These three happens to be the largest in number. There were other smaller tribes within that area. So they were always at war with one another. The implication of that is that they became weakened so that it was very easy for aggressors to come and attack them and be able to subdue them individually. A warlike tribe that came from the area you call Germany today, they call them Saxons, attacked that part of the world and were able to subdue the different tribes. That means you are talking of the Gaels, you are talking of the Welsh, the what's it called, the Scots, and so on and so forth, and brought them under the control of their own king. That was what we call the Norman conquest of that part. The Norman tribe came from that area you refer to today as Germany. They now conquered all the tribes and brought them under the control of a Norman king. The very first Norman king historically was William the Conqueror, who now decided that, yes, these are my citizens. They must pay tax to me. So the whole idea of governance then started with payment of tax. The king, who is now settled in the middle, sends out his men to collect tax from all the various tribes and communities. But as at that time, each of these settlements, the Irish, the Scots, the Welsh, they already had established rules, laws that is local to them, what you call customary law, which they have been using, which they still kept. But one thing as at that time is that everything about justice, once there is dispute, is always resolved by the king or in the name of the king. So that when the Norman king now sent out his men to collect tax, he also gave them the authority to act as judges on his behalf. So that once there's a dispute in any settlement, they have the power to resolve that dispute in the name of the king, which they normally did by applying the local custom that applies to that particular area. And they record everything in writing because they were well educated. So when these people now started gathering their reports year in, year out, at the end of a period, a picture emerged. We now have a country, so-called, headed by the king. But what was observed was that the laws being used from one part of the country to another was different. And that was simply because the custom from one part of the country was different. The Scots had their own custom and language differently. The Irish had theirs, the Welsh had theirs. So it now started causing problem, because you might discover that what constitutes an offense in community A might not be an offense in community B or C. Naturally, if somebody commits an offense in community A, since it's within the same area, it will run to community C. That particular thing might either not be an offense or it has a lesser punishment. And so people now started dodging the implication of the offenses they have committed by running from one place to another. This is one of the problems. There were so many other problems. But what the king did was very simple. He got his men together and said, how do we resolve a problem like this? We want to rule these people. We want laws that will be just. Another problem was that some of the punishment for some offenses in some areas were so harsh. I'll give an example. Stealing has always existed since man was created. In some communities, the punishment for stealing is to behead the person. That's cut off the head. In some communities, you cut off the hand used to commit the offense. Whereas in some communities, they will be thrown into prison for a given period of time. Naturally, the average person who commits the offense, where his head will be cut off, will prefer to run to a place where he will go to prison and still live to tell the story. And like I said, this was some of the problems that arose. The king and his men now agreed that there must be a way to solve this problem. They now came up with a system. We call it the doctrine of judicial precedence. Judicial precedence. Now, the doctrine of precedence, we are going to see it in your pack, is simply to the effect that once we have a case, let's say case number one, and the facts of case number one are A, B, C, and D, and the judgment given in that case is X. I'll take that again. We have case number one, and in case number one, there are facts A, B, C, and D. And the judgment given based on the custom was X. The rule is that if we now look around and discover that that is the most reasonable judgment as far as that particular offense is committed, we adopt it. So that by the time everybody is going out the following year, everybody will be armed with a copy of this judgment. So that wherever you get to, whichever committee you get to, and there's a case similar to this that asks facts A, B, C, and D, the people will now invoke the name of the king and say the king has ordered that where this is the fact, this must be the judgment to be delivered. No matter what your own custom is, that is the order of the king. That was how they started using what we call judicial precedence. We're going to see that it still applies in Nigeria till today, because that was the system brought in by the colonial masters. They now started gradually, and by so doing, they now started enforcing the most reasonable set of laws from different parts of the country and made it spread across the whole country using the authority of the king. That was why at a point in time, the judgments to be obtained in England, no matter what part of the country you are, will always be the same, because the judges will be following the same precedent based on the order of the king. That was how the word common law came into existence. You are going to see that the meaning of common law is the laws that became common to every part of England, unlike the old system where you have situation where different set of rules were being applied by different communities. And to make it better, one of the kings in England now decided that it is easier to establish courts in different parts of the country so that judges will be there permanently. exercising the power of the king. That was how what they call the common law courts in England came into existence. So that after about 100 years of Saxon rule, the same set of rules, laws, were being used from one part of England to another by development of what we call common law. And common law developed through one system. I'll repeat it again. We call it the system of judicial precedents, because the judges were following the same precedent year in, year out. However, there was a problem, or some problems arose because of this. Because the judges were following the same set of precedents. While the law remained stagnant, the community started developing. Aside during the Industrial Revolution in Europe, so many principles changed, but the law could not catch up. And the implication was that it got to a stage where so many problems arose that was not provided for by common law. And the judges themselves became so complacent. They were only following the same set of rules for the past 200-300 years. There were so many problems that arose that was not provided for by common law. And the implication is that people now go to court and end up not getting a remedy. Or even where there's a remedy, the remedy given is often outdated and become irrelevant. Because of problems like this, people now start complaining to the king. Yes, we know we have the courts, but they are not doing what they are supposed to do. Justice is not being met. It's either the remedies are non-existent, or even where they are existent, they are outdated and irrelevant. And people now started taking the laws into their hands. When this became apparent, what the king did is this. Every time there was a complaint about common law from the citizens, he directs such a complaint to one of his officers. The officer in question was called the Lord Chancellor. The Lord Chancellor in England was the second most powerful person in the kingdom. He is actually referred to as the deputy of the king, because they refer to him as the keeper of the king's conscience. The people appointed as Lord Chancellors were always bishops, and they were well trained and versed in what we call canon or religious law. So since they have knowledge of the law, majority of the kings, anytime there's a problem with the law, will direct it to them. Go and meet the Lord Chancellor. The office of the Lord Chancellor is referred to as the Court of Chancery. Court of Chancery. You see this in your textbook, Chancery. Now, anytime people now come with complaints, there's a problem with common law. It's either there's no remedy or the remedy is non-existent. The Lord Chancellor will now use his own discretion based on what he believes is fair and just to give a remedy, so that people will go away, even in some instances where the available remedy is not adequate. He will create a new remedy, because the principle of, as far as the Lord Chancellor is concerned, is that once there's a problem, there must be a solution. That is why people now realize that once you have a problem with common law, go to the Lord Chancellor. You are sure to get a remedy. And people now started flocking to the Lord Chancellor's office. That's the Court of Chancery. When the Lord Chancellor now observed this, he now laid down a rule that no one can come directly to him with any problem unless you go to the common law court first. That means you must go there. And when you are coming, you will bring the judgment you obtained. Or if there's no judgment, they tell you no judgment, just get a document to that effect that your case is all recognized, because that problem does not exist as far as common law is concerned. That was how it started. And that was how what called the doctrines of equity was developed. Equity was developed for one purpose: to correct the shortcomings of common law. So it was like more or less a complementary to common law. Once there's a problem with common law, people will now go to doctrine of equity, and the Lord Chancellor will now give a remedy. But like I told you, the Lord Chancellor will first of all ask you, what remedy did you get? It is only where the remedy at common law is not okay, or is non-existent, that the Lord Chancellor will intervene. If the Lord Chancellor is of the opinion that the remedy at common law is okay, he will say, yes, I'm satisfied with that remedy, and that's also my own judgment. That's how it now started developing gradually, such that at a point in time in England, there were two separate courts. The common law courts, which was administering common law, and the courts of chancery, which was administering equity. But we are going to see from the textbook that equity was not a complete system of law. It is only complementary. It only applies in those instances where common law is defective. So that people now got to realize that once you are aware of your right, you can either go to the common law court, or if you are not satisfied, you go to the court of chancery for an equitable remedy. But this same issue has a problem as well. I want to highlight the two problems. One, you need to pay twice to get remedy in the court of equity, because you need lawyers to argue your case in the common law court. If you are not satisfied, you go to the court of chancery. You still need lawyers to argue your case. The average common man could not afford to pay twice. So that even where they have a remedy, they will just forgo it because they don't have the money. But the second one is this. Common law was well established that even before you go to court, you are likely to know the judgment you will get because you know the precedent that the judge will follow. Unlike equity that is based on the discretion of judges, people now start criticizing equity, that equity is not consistent. Common law is consistent. To now solve that problem, the Lord Chancellors developed a set of rules. You are going to see them in your textbook. We call them the maxims of equity. The maxims of equity were developed as a guide to judges in the court of chancery. So when they want to give a judgment, they will not just say, this is my judgment. It must be based on a particular rule. It guides them as to how to exercise their discretion so that their discretion can be as uniform as possible. We call them the maxims of equity. If you look at your textbook, you see them there. There are 12, but some are very, very important, and we're going to discuss them in the course of our discussion in class. For example, one says that he who comes to equity must come with clean hands. I'm sure a lot of us have heard this before. That's one of the most popular. Another one is he who seeks equity must do equity. We have others. Equity shall not suffer a wrong to be without a remedy. We all know what that means. That means where there's a problem, there must be a solution. That's the basis of equity. That's actually number one. But we have so many other maxims that are applicable to specific aspects of lives. Some of them we're going to look at when we're dealing with trusts, which is a very important component of our syllabus. Because we're going to see that the development of the law of trust is actually one of the most important contributions of equity to English law, and which is what we are using in Nigeria today. We're coming to that later. But please, if you go to your textbook, you see the 12 maxims. It is listed there. Equity presumes an intention to fulfill an obligation. Equity looks upon that as done, which ought to be done. When we get to all this and its practical application, I'll still draw your attention back to this. But don't let us waste too much time on it. I will always call you back to those maxims where they are applicable as far as our syllabus is concerned. Now, the second problem was resolved by Parliament. That's the lawmaking body in England. When the complaint of having to pay twice to get judgment eventually in the Court of Chancery came up, the lawmaking body in England, Parliament, passed a law between 1873 to 75. These laws are referred to as the Supreme Court of Judicature Acts. The shortened name is Judicature Acts. You see it there, Judicature Acts. But the full name is Supreme Court of Judicature Acts. What the Supreme Court of Judicature Acts did was this. It abrogated or cancelled. When I use the word abrogate, It means you cancel something, but what has been done under it before remains valid. That's the meaning of abrogate. That's what you see in your part. That law, Judicature Act, abrogated the common law courts and the courts of chancery as it existed then, because there were two separate courts handling the same case after one another. And the average common man will need to go to the common law court first, where he will incur expenses. If he ends up getting a remedy in the court of chancery, he must also pay. So this law, Judicature Acts, cancelled the two courts and replaced them with a single court, which was now given the power to administer both common law and equity. I always clear this. What Judicature Act did was to actually merge the administration of common law and equity under one single court. That means the common man does not need to go to the common law court for a common law remedy, then go to the court of chancery for an equitable remedy. You can approach the same court, just like we have in Nigeria today, and ask for either a common law remedy or an equitable remedy. That is to save the common man from having to pay twice. And that was the system brought in by the colonial masters into Nigeria. That's why all our courts in Nigeria administers both common law and equity. The only thing is this: common law is still a complete system of law, and equity is only complementary. And common law is based on the discretion of the judge. Common law, equity is based on discretion of the judge. That means if your conduct does not deserve the remedy of equity, a judge will not give you. That's why I mentioned that remedy, that particular maxim: he who comes to equity must come with clean hands. And that is what we still have in Nigeria today. So if we go back to what we were discussing, when the colonial masters were coming, they took common law, they took equity, brought it with them. But there's a third component in that box that we call statutes of general application. That's the third component of English law brought in by the colonial masters. Statute simply refers to laws made by the lawmaking body, what we call parliament in England. Meanwhile, common law was developed by judges based on precedent. Equity was also developed by judges based on their judgment. That means they are not laws made by a lawmaking body. Rather, they are laws made by judges based on their judgments. That's why we call them case law systems. That means laws developed from previous cases. Because once you have laid down a judgment, judges will now keep following it year in, year out by adopting the doctrine of judicial precedents. We're still going to mention that briefly. Now, we're going to see that under the law, when the British colonial masters were coming, they now selected some of the statutes made by Parliament in England, used to govern England. Not all, because some cannot be used in the colonies. They now selected some that may be useful in the colonies. These are the ones we call statutes of general application. And they use three major criteria to determine which one they will take and make use of in the colonies, which includes Nigeria. One, the particular statute must have been made applicable to every part of England. That means that it must have covered the whole of England, so that when you are applying it in Nigeria or any of the other colonies, it's as if it's also a part of England. What it means is that it must not be one that applies to Wales and does not apply in Scotland, or applies in Wales and Scotland but does not apply in Ireland. It must have been made applicable to every part of England. Then it qualifies. It means the first qualification. Two, it must have been made not later than the first day of January 1900. We call this one the cut-off date. What it means is that all the laws, where I'm going to mention a few, which we're going to see we're still using in our syllabus here. All the laws that are being used must have been passed before that date. That means it must have been passed in England by Parliament before the 1st of January 1900. In Nigeria today, we have Sale of Goods Act 1893. That's the law we're still using, although we are not, it's not in our syllabus. Partnership in Nigeria is regulated by the Partnership Act of 1890. It's one of the laws brought in by the colonial masters. But we're going to see that the most important one we have in our syllabus is the one that regulates wills. We call it the Wills Act of 1837. When we are dealing with wills, I'll bring you back to this. This law was made in 1837. If you look at that year, it is before 1st January 1900. What that means is that any law made after this date in England does not qualify as a statute of general application. So I'll take the criteria again. One, it must have been a statute that is applicable to every part of England. Two, it must have been made latest by the 1st of January 1900. And thirdly, is very important, is that it must not be contrary to a local statute. You are going to understand that when we get to Nigerian legislations. That means it must not be contrary to a law made in Nigeria. That's why you're going to see that if we have a law in Nigeria and the provision is contrary to a received English law, the Nigerian law will supersede it. That's the position. So those are the three criteria that determines whether an English statute is applicable in Nigeria or not. One, it must have been applicable to every part of England. Two, it must have been made not later than the 1st day of January 1900. And three, it must not be contrary to a local statute. And we're going to see that the most important one in our syllabus is the Wills Act of 1837. We're going to discuss that. When we get to that area, I will draw your attention back to this again. That's why you'll be able to appreciate that we're discussing one of the laws brought in by the British colonial masters. That's for first source. That's English law. The second and the most important one is Nigerian legislations. That simply means that all the legislations made by various governments, both military and civilian in Nigeria, since independence till date, we call them legislations, because you are going to see that we have the legislative arms, both at the federal and the state level. That's why we don't call our own parliament. We call them the legislature in this part of the world. But from England, we call it parliament. That's the body that makes laws over there. Now, we're going to see that in Nigeria, we have practiced at independence the parliamentary system. But from 1979, we adopted the presidential system. However, one thing is that everything is still based on the constitution of the country. That's why we're going to see that when we talk of Nigerian legislations, I break them down into four major components. One, acts of National Assembly. The word is acts. We refer to it any legislation passed by the National Assembly. That means by both houses, Senate and House of Reps. Once it is assented to by the President, it's referred to as an act. That's why we have Companies and Allied Matters Act. If you look at the Charter Institute of Stockbrokers, we say it was actually chartered by Act 105 of 1992. That's what you see there. That means it is a federal law. But along the way, the second one, we have the word decree. Decree. Decree is what is used under the military. That is for the laws made under a military regime at the federal level. You are going to see that so many decrees that were made under the military is now referred to as an act. Once we revert back to civilian dispensation, we now make a law that refers to it as an act. I'll give you an example. If you look at the Charter Institute of Stockbrokers Act, which is chartered by Act 105 of 1992. In 1992, we were under a military dispensation. It was actually Decree 105 of 1992. But now we are under a civilian dispensation. We refer to it as Act. So that everywhere you come across the word decree, you know it is a law made under a military regime at the federal level. Then we come to the state level. We have laws of the State House of Assembly, laws of Oyo State, laws of Lagos State, laws of Kano State. Those are the ones we refer to it as laws. You know, the common man on the street calls everything law. But in real sense, for this level, once you use the word act, you realize it is made at the federal level. Once it says it's a law, it is made at the state level under a civilian dispensation. But under the military, we call it edicts. Edicts are made by state military governors, while decrees are made by the federal military government. Under the dispensation that is civilian, the National Assembly makes acts of the National Assembly, while state houses of assembly makes what we call laws of the State House of Assembly. So that this distinction is very, very important. Once you come across anything that says this is a law, you know it is made at the state level. If it says it's an edict, it's also made at the state level, but under a civilian military dispensation. But acts and decrees are made at the federal level. Decrees are made by the federal military government, while acts are made by what we call the National Assembly. Note, however, like I said, when we are looking at the most powerful source of law, it is the Nigerian legislation, because it has been used to cancel so many provisions of received English law and replace it. When we are dealing with company law, we're going to see that historically in Nigeria, we had the Companies Act of 1969, which replaced the received English law that we were using before. But it has now been replaced by CAMA. So you are going to see that it can abrogate any received English law at any point in time. And along the way, we're going to see some provisions relating to this. So when we are dealing with almost all the laws we have in our syllabus, we are going to focus on these two sources of law. English law, which I said has three components, but we are not going to call it English law again. Rather, we just address it by its component name. We say this is a common law principle, this is an equitable principle, or we say this is a statute of general application. And along the way, when we are making reference to Nigerian legislations, once we say act, we know it's one made in Nigeria at the federal level. When we say laws, or when we say decrees or edicts, we know exactly what we mean by that. So that's for the very first introductory aspect. I hope that is clear. So let's now go to the next one. We are going to look at the next one. Nigerian, that's the court system in Nigeria. Yes, let's move to the next one. Slide 2. Here, we simply want to quickly look at the structure of courts, because there's no way we will talk of laws and will not talk of the structure of courts in Nigeria. Sorry, please, let me just quickly. Sorry, please, let me I want to go to that particular slide. It seems my system is. Yes, now let's quickly look at the structure of courts in Nigeria. Yes, I think you can see it clearly now. Now we are looking at the picture of what the courts in Nigeria looks like. I always start by saying that when we're discussing this, we're mentioning what I call the superior courts as laid down by the Constitution. We're going to see that we have so many tribunals, like the one dealing with investment and so on and so forth, but they are still not recognized as superior courts by our Constitution. We are still going to mention them in passing, but the picture we have here is actually the picture of what the structure of courts looks like in Nigeria. We're going to see that it looks like a pyramid, narrow at the top and wide at the bottom. But we are interested in the first three levels. That is the Supreme Court at the top. The second level is the Court of Appeals, while the top
Am I the only one that can't hear him again? Okay.
All of
I cannot hear him as well. All of us cannot hear him.
I cannot hear you, sir. I cannot hear you too.
We cannot hear you, sir. Please.
Can you hear me now? Hello?
Yes, sir. We can.
Yes, we can hear
Sorry,
you.
I think the network must have broken. Let me take that again.
Okay, sir.
Yes, like I said, we are now looking at the third level. At the third level, we have the federal high courts, the state high courts, the customary courts of appeal, the Sharia courts of appeal, and the National Industrial Court. That one is NIC. I'm going to describe all of them. But you are going to see that below it, we have magistrate courts and customary courts. For the purpose of syllabus, we are not interested in that because they are inferior courts. We are interested in our syllabus in what we call the superior courts of records. And that is from the Supreme Court up to the third level. Now, when we are discussing this topic, there are three things we always look at. One is the word jurisdiction. Jurisdiction. You are going to see it in your material. The word jurisdiction means the type of case or cases the court has the power to handle. And when we talk of jurisdiction, we're going to see that we have two types of jurisdiction. One is what we call original jurisdiction and what you refer to as appellate jurisdiction. So when you are reading through your material, you are going to come across this word. We say the court has original jurisdiction over this, or it has appellate jurisdiction over this. What we mean by original jurisdiction means that a person can approach that court with such a case fresh, and the court will have the power to hear it. Let me give an example. If somebody owes me money and I want to sue him, I can sue him to the state high court because the state high court has original jurisdiction as far as that case is concerned. However, I cannot go to the Court of Appeal or the Supreme Court because they don't have original jurisdiction over such a case. But if I sue him to the state high court and I am not satisfied with the judgment given at the state high court, I can now decide to take the same case to the Court of Appeal. The Court of Appeal will now be handling that case in an appellate jurisdiction. That means it is hearing it on appeal. So you're going to see that those words have a very clear meaning. So when we say a court is exercising an appellate jurisdiction, that means the case has already been heard by a lower court. It is now being heard by that particular court on appeal. But when we say a court is exercising original jurisdiction over a matter, that means that court is hearing that case fresh for the first time, and it has the power to do so. So that when we are now dealing with that area, because when we are dealing with these courts, we are going to see that some have both original and appellate jurisdiction. Some have only appellate jurisdiction, while some have only original jurisdiction. Then we are going to look at the personnel of the courts. When I say personnel, we mean that who are the people that handle cases in the courts. When we look at the personnel, we look at one, how are they described? We are going to see that at the state level, at the high court level, we say a judge of a high court. But when you get to the court of appeal, we say justice of the court of appeal or justice of the Supreme Court. That's the key thing. There's a way we describe them. But there are some that has particular names, like Sharia Court of Appeal. We call them Grand Qadi. I'm coming to all these ones so that we will not be disturbed by anything. Now, we are going to see that when we are dealing with the personnel, we will look at who appoints them and what is their qualification. That means to be appointed to that court, what is the minimum qualification you must have? Because those are the areas we focus in on our syllabus. So let me now go to the first one. Let's start with the Supreme Court. The Supreme Court is the highest court, as you can see. The Supreme Court is the one that is in Abuja. We have only one in Nigeria. And that court has basically an appellate jurisdiction. That means all appeals coming from the Court of Appeals goes to the Supreme Court. You cannot go to any other court. That means if you have been to the Court of Appeal with any matter and you are not satisfied, then the only court that can handle it, which is the court of last resort in Nigeria, is the Supreme Court. But we are going to see that the Supreme Court also has original jurisdiction over two types of cases. One, any case between a state or states and the federal government. Most of us will be aware, 2023, there was this case relating to the issue of the Naira, where some states sued the federal government and the what's it called? And the central bank to court. That matter was handled by the Supreme Court in its original jurisdiction. Most cases between two states in the federation, that's the second one. That means if there's a dispute, especially over border disputes or any other dispute between two states in the federation, it is only the Supreme Court that handles such cases in its original jurisdiction. So those are the two types of cases that the Supreme Court can handle in an original jurisdiction. Besides that, it has only appellate jurisdiction over all cases coming from the Court of Appeal, whether it's a civil matter or a criminal matter. Is the Supreme Court that handles it. Now, the Supreme Court is headed by the Chief Justice of the Federation, assisted by other justices. They are called justices. And they are appointed by the President of the Federal Republic of Nigeria on the recommendation of the National Judicial Council. That's the body that recommends people for appointment to all the superior courts. National Judicial Council is called the NJC. It's also the one that recommends their removal and disciplinary action against them. Now, to be appointed as a justice of the Supreme Court, the provision of the Constitution says that that person must have qualified as a legal practitioner in Nigeria for a minimum of 15 years. That's the least requirement. Although we're going to see that there's nobody in the Supreme Court today that has not qualified for anything less than 30 years. The reason is that they rise from the lower courts and they must have spent some years in the lower court. But the provision of the Constitution is 15 years. Just need to know this because you may come across it in the exam. That is for the first one. The second one is the Court of Appeals. From the name, that is the court that handles all appeals from the 5 courts below it. That's Federal High Court, State High Courts, Customary Court of Appeal, Sharia Court of Appeal, and National Industrial Court. All appeals from those 5 courts goes to the Court of Appeals. That's the court that has the power to handle them in its appellate jurisdiction. But that court also has original jurisdiction over cases relating to election of president and vice president of Nigeria. Note that once there's election in Nigeria, the election tribunal is handled by the Court of Appeal. It's after that it goes to the Supreme Court. But it is handled by that court in an original jurisdiction. That's the only type of cases relating to election or whether the office is vacant and so on and so forth. That's the only area over which the Court of Appeal has an original jurisdiction. Besides that, it has appellate jurisdiction over all matters coming from the 5 courts below it. The Court of Appeal is headed by the president of the Court of Appeal, assisted by other justices of the Court of Appeal. They are called justices as well. And they are all appointed by the President of Nigeria on the recommendation of the NJC, that's National Judicial Council. The qualification for appointment at this level is 12 years as a legal practitioner in Nigeria. That's the minimum requirement. 12 years as a legal practitioner in Nigeria. Then we go to the 3rd tier, where we have 5 courts. At this level, we have 2 courts that are federal courts, and we have the remaining 3 are state courts. The first one is the Federal High Court. The Federal High Court was established in 1979 as the Federal Revenue Court. The name was now changed. It deals with all cases relating to federal government revenue. That means cases involving customs and excise and all organs of all the agencies of federal government, NDLA, EFCC, ICPC, and every other thing. But besides that, it has jurisdiction over cases relating to banking, admiralty, shipping, and so on and so forth, and cases that has to do with diplomats and all these things. You see all these ones in your pack there. It has only original jurisdiction. It does not listen to appeal from any lower court. It does not have the power to handle appeals. So the Federal High Court is a federal court. It has only original jurisdiction over matters relating to federal government revenue and all agencies of federal government. I've mentioned them. Then it is headed by a chief judge appointed by the President of Nigeria on the recommendation of NJC. The qualification for appointment of all the judges at this level is 10 years as a legal practitioner. That means you must be a legal practitioner of no less than 10 years. So that is for the Federal High Court. Now let's quickly look at the National Industrial Court before I go to the State Court. The National Industrial Court is also a federal court. It is established out of the Federal High Court because it was simply one jurisdiction of the Federal High Court that was removed. Before, it was the Federal High Court that handles all cases relating to trade disputes in Nigeria. But because of the volume of this case, the National Industrial Court was now created to handle all cases relating to disputes between employees and employers or between labor union and government and so on and so forth. It has only an original jurisdiction. It is the court that exclusively handles every case dealing with trade dispute as far as Nigeria is concerned. That is their own area. It is also headed by a chief judge appointed by the President of Nigeria on recommendation of NJC. And the qualification, like I mentioned earlier on, is also 10 years as a legal practitioner in Nigeria. Then we now go to the state courts. This is the State High Court. Don't forget that the State High Court also exists at Abuja, the Federal Capital Territory. We have the High Court of Abuja, which is the equivalent of the State High Court. It's the same thing. It is not a federal court. It is handled by the state, the Abuja, the municipality of Abuja there. This is the highest court at the state level. It has basically what we refer to as an original jurisdiction over all cases that arises within the borders of the state, whether civil or criminal, provided it does not fall within the exclusive jurisdiction of a federal high court or the National Industrial Court. That means if it's a trade dispute, it's National Industrial Court, even if it's within Lagos State. If it is smuggling, it is Federal High Court, even within Lagos State. But we're going to see that that court has powers to handle every case that arises within the ambit of the state, whether civil or criminal, in its original jurisdiction. Then the State High Court also has appellate jurisdiction over all cases coming on appeal from magistrate courts, and in some states, like Lagos State, customary courts. So it is the court that is highest at the state level. It has both original and appellate jurisdiction. But the appellate jurisdiction only covers all appeals from the magistrate courts, and in some cases like Lagos, customary courts. But we're going to see that this particular court too, right, is a state court, and it is headed by CJ, that's Chief Judge of the state, appointed by the governor, the state governor, on the recommendation of the NJC. It's still the NJC that recommends all of them. That's National Judicial Council. And the qualification for appointment is also 10 years. That's for the state courts. Then the other two courts are equivalents of one another. Customary Court of Appeal and Sharia Court of Appeal. We are going to see that in some states, they practice both what they call ethnic customary law, which covers almost every state in Nigeria, while some states has both ethnic customary law and Sharia or Islamic customary law. In those states that practice Sharia law, they have what we call the Sharia Court of Appeal. In those states that practice ethnic customary law, they have the Customary Courts of Appeal. These are courts that can be established. It is not a must. But don't forget that the State High Court is a must under the Constitution. That's why if you look at Lagos State does not have a Customary Court of Appeal. Neither does it have a Sharia Court of Appeal. That's why appeals from customary courts and magistrate courts in Lagos goes to the State High Court. But in those states that have a Customary Court of Appeal, this court only hears appeals coming from the customary court. It has only appellate jurisdiction. All appeals from the customary court in that state goes to the Customary Court of Appeal. While in those states that practice Sharia law, all appeals from the area courts in those states in the north, they call them area courts, where they practice Sharia law, goes to the Sharia Courts of Appeal. That is why those two courts I said are equivalents of one another. They only have appellate jurisdiction. Now, the core distinction is that the head of the Sharia Court of Appeal is called the Grand Qadi. Grand Qadi, K-H-A-D-I. That's the title for the head of the Sharia Court of Appeal. And the judges are called Qadis. But in the Customary Court of Appeal, they are called judges as well. They don't have a special title. And the head is the president of the Customary Court of Appeal. They are all appointed by the governors of the various states that needs them, and is on the recommendation of the NJC, because they must have qualified for not less than 10 years as a legal practitioner in Nigeria. That means that basically they must be legal practitioners of no less than 10 years. The only thing is that to be a Grand Qadi, you must also be well versed in Islamic law. And when you have to go to the Customary Court of Appeal, that means you must also be very good in the local custom as far as that area is concerned. So that is for the courts we want to look at. We have looked at the three levels. If you look at your material, there's little material on magistrate courts and customary courts because they are not too relevant as far as the syllabus is concerned. So that is for the court systems. That is the first area. Now, let me just take, if there's any question on what we have discussed so far before we now go to the law of contracts. Any question from anybody? Well, if there's none.
No, Barrister, sir.
Yes, sir.
I maybe I don't know where I heard you well. Are we going to have the materials sent to us and asking so to follow up properly?
Yes.
Because
you need to
okay.
ask the institute has a material. Coincidentally, I prepared the material. That's why I said I'm using it.
Okay.
As I'm just using this slide to cover the areas that are very pertinent that you need to, because the material is very bulky. It's almost 200 and something pages.
Okay.
I hope that's clear, sir. Yeah. So the advantage of the slide which you are going to get is that when you are now preparing for exam, you'll be able to know the areas to focus on in the material. I hope that's clear, sir.
Thank you. It's clear to me because I'm now reassured that I will have the slide.
Okay, fine. No problem. So let's now go to the major topic for tonight. That's the law of contracts. We are going to see that the basis of everything that is business all over the world is the law of contracts. And we start by saying, what is a contract? You see, the average person does not realize that contract is a way of life. There's hardly any human being that can exist in the absence of contracts. We are going to see that a contract can be defined simply as an agreement. I use that word again. An agreement between parties which the law will enforce. An agreement between parties which the law will enforce. Now, when I use this definition, I always like starting this way. One, take note, the law does not define a contract as a written agreement. One thing we must first of all let's settle with is this. The law says an agreement. That agreement may be made orally, in writing, or by conduct. But the key thing is that the parties to the contract must have agreed. And we're going to look at the component of the agreement itself. I'll take it again. An agreement between parties. Not one thing. I did not say between two parties again. You are going to see that there are various forms of agreements. Some of them have two parties. That is the minimum. But some contracts have three parties. Because we're going to look at contracts relating to agency. There are always three parties involved in agency. We're coming to that later. When you look at contracts where people borrow money and stand as guarantor, contracts of guarantee, there are three parties involved. So that's why at times when I give this definition, I always like breaking it down. An agreement between parties which the law will recognize and enforce. What that means is that every contract is an agreement. But I always put it the other way around. It is not every agreement that is a contract. If I invite you to my house and I promise you a bottle of wine, and you agree to come down, we have an agreement between us. But supposing I fail to give you the bottle of wine, the issue is, do you have the right to sue me for my failure? If you can sue me, it means that the agreement between us is a contract. But if you cannot sue me, it means the agreement is not a contract. So that's why I want us to paint that picture. But another thing I want us to notice this. We are going to see that we all enter into contracts every day, even without uttering a single word. Majority of us never realize this. Every time you take a bus, you stay at the bus stop. The conductor comes shouting your destination, maybe Ikeja, 500 naira. You climb in without uttering a single word. When everybody is paying, you give him the color of the money everybody is paying. Nobody knows whether you can even talk or not. By the time you get to your destination, somebody has already told the conductor, Maryland, where you drop there and you go. You'll be amazed that you have not uttered a single word. But within that short thing I've just mentioned, you have just concluded a contract. Or to make it better, because I'm going to use so many examples. These days, we all enter into supermarkets. You walk up to the shelf, pick up items, take it to the cashier. She rings it up, you pay the money without uttering a single word to anybody. You carry your goods and you walk out. You have just concluded a contract for the sale of goods. You'll be amazed. That is what we do every day. But let's now break down the legal component now. What are the requirements for a valid contract to exist? That means, what are the requirements that will make the law enforce an agreement between the parties? There are 5 of them. And what I always say is that, I always tell my students, the first thing you do when we're dealing with this is just raise your hand. There are 5 fingers on your hand. It will always remind you that there are 5 components of a valid contract. These are offer, acceptance, consideration, intention to create legal relations, and capacity. Those are the 5. I'll take it again. Offer, acceptance, consideration, intention to create legal relations, and capacity. And that's what we want to break down first. Because the first thing is, every contract is an agreement. That means if there's no agreement, there can be no contract. And I always say that the component of the agreement is 1, offer plus acceptance. That means once A makes an offer and B accepts, we now say they have agreed. But note that it is not yet a contract until all the other requirements are present. One thing I always tell people is that the 5 components of a contract, they are mutually exclusive. That means if one of them is missing, there's no contract. That means all the 5 must be there. The only thing is that the first 2 are the basic foundation, because that's the agreement upon which the other components will be built. Now let's go to the first one. An offer is defined as a definite promise made by a party called the offeror. That's the person making it. To another party called the offeree. A makes a definite promise to B. A is the offeror. You see this in your book. While B is the offeree. That's the person to whom the offer is made. But note one thing. I use the word here, a definite promise. I did not say in writing. So you must always avert your mind back to what I've said before. That means the offer may be made orally, in writing, or by conduct. I'll take that again. The offer may be made orally, in writing, or by conduct. The only thing is that it must be made by one person called the offeror to another person called the offeree. What that means is that it must be communicated. I'm coming to that later. But if we say a definite promise, one thing we are saying is that every offer must be a promise, but it must be a promise that is asking for something in return. It must be a conditional promise. I will give you my car is a promise, but that is not an offer because it has not asked for anything in return. But if it says, I will give you my car if you give me 1 million naira, that is an offer. So you should look at the nature of this because you are likely to come across situations in your exams where you need to identify whether an offer has been made or not. I will give you my car is a promise, but does not ask for anything in return. For a promise to qualify as an offer, it must ask for something in return. That means to say, I will do this if you do that, or I will do that if you do this. If you look at your conduct when you are buying goods, that's what you are doing. That's what you are telling the seller. Give me a bottle of Coke and I'll give you 500 naira. Let me have a bottle of Coke, I'll pay 500 naira. It is an offer. You are making a promise, provided the other party does something in return. Please note this very well about the nature of an offer. Then we say that an offer can be made to either a single person or a group of persons or even to the whole world. That's the first one you see in your textbook there. You can make an offer to one person If I walk into the class now physically and I say, Mr. A, I'll give you my car for 1 million naira, I've made that offer to Mr. A alone. You see, everybody in class heard what I said, but it has not been communicated to them. It has been communicated only to Mr. A as far as the law is concerned, and he's the only one that can accept that offer. On the other hand, you can make an offer to a group of persons. We've seen it when you look at adverts on radio, television. This offer is open only to people above the age of 18 or to social class of persons. It is only people that fall within that class that can accept that offer. But the law is this: you can also make an offer to the whole world. That is what technology has brought about now. Because these days, you can stay in your house, watch a program that will, from England, from US, that will contain an offer, provided it is not restricted. You can go ahead, pick your phone and accept it immediately if you are aware of it. The only thing is that it must be addressed at you. It must be an offer that is not restricted. An offer that is not restricted to any particular person is referred to as an offer made to the whole world. That's why if you look at your material, you see the case of Khalil and carbolic smoke bulbs. It is held that an offer can be made either to a single person, to a group, or to the whole world. But note one important thing, and this is the area I want to. We're going to see that here we say want to distinguish an offer from invitation to treats. You must be very, very particular about this. Look out for it. An invitation to treat is something that looks similar to an offer, but the law says it's not an offer. Rather, it is a preliminary. Is more or less asking the other party to make the offer. The line between offer and invitation to treat is very thin. That's why I always discuss it by giving you examples. If you look at your material here, advertisement of auction sales, display of goods, even where it has a price tag on it, that's the most common one. The law says that where someone displays goods, enter into a supermarket. The owner of the supermarket will display goods on the shelf. He will put a price tag on it. The law is that that is not an offer by the owner of the supermarket to sell. Rather, is inviting members of the public to make the offer. It is the person that picks up the item and goes to the cashier that's making the offer to buy. That's why if you enter into a supermarket and you pick up an item, you can still change your mind even when you get to the cashier. You can say, sorry, I don't want this. Nobody can compel you to buy it, because it is when you give it to the cashier that you are making the offer to buy. And if you drop it, nobody can say go and pay, because that is the nature. This area is very, very important within our syllabus. Now, let me tell you the importance of this. When we are dealing with company law, we are going to see that we are going to deal with prospectus. A prospectus is a document used by companies to make shares available to members of the public. We all know what the prospectus means. But do you know, if you read the prospectus, you say offer for subscription. But in law, the content of a prospectus is not an offer. Because Zenith Bank recently brought out a prospectus, and it says it's offering to the public so number of shares at so price. That is not an offer, because it is the member of the public who picks it up that will now fill the form. It is when you fill the form and submit it that you are offering, you are making the offer to Zenith Bank, which they may or may not accept. That's why if you send in your money with your application and they don't give you share, you cannot sue them, because you are the one making the offer to them, which they may or may not apply. By bringing out a prospectus itself is not an offer. Rather, it's what they call an invitation to treat, an invitation to make an offer. We have so many examples there. Tenders, we all know what tenders are. That's where government says tender for social project. At times we even pay, but you may not get the project. You may not get the contract, because invitation for tenders is not an offer. It is the person that responds to it. So by implication, an offer is definite and can be accepted, but an invitation to treat is not definite. It may only result in an offer. It is nothing more than an invitation to make an offer. And you are showing your intention to enter into a negotiation. You have not said, I'm selling. But note that at times, if I walk into a class like this one physically, I said, ladies and gentlemen, I intend to sell my car. It is going for 1 million naira. I've not made an offer to anybody. I'm only inviting members of the public who are interested to come and tell me. I say, I'll buy. And I can just look at the first one and say, sorry, I'm not selling to you. I don't like your face. That person cannot sue me because I've not made an offer in the first instance. What I've done there is an invitation to trade. But on the other hand, if I come into class and say, Mr. A, I'll give you my car if you give me 1 million naira, that's a definite promise to Mr. A. An offer has been made to him. So that's why it's always very important to ensure that you are able to draw that distinction between offer and what you call an invitation to treat at any point in time. So that's the first one. Now, let's quickly go to the next page. We have looked at acceptance, at offer. Now, let's go to the second requirement, that is acceptance. Acceptance is said to be the final agreement with the terms of the offer. That means the offeree agrees totally, because the rule is that an acceptance must not change the terms of an offer. You must not introduce a new term, neither must you withdraw from it. So that's why we define it in the part. It says a total and unconditional assent to the terms of the offer. If somebody comes and says, I will give you my car if you give me 1 million naira, that's an offer. You say, I will buy, but I'll pay you 990,000. That is not an acceptance. That is why on our page here, the first thing we have is what we call a counter offer. A counter offer is any purported acceptance. That means you are claiming to accept, but you have varied or changed the terms of the offer. And the law is that a counter offer is not an acceptance. Rather, it destroys that offer. Let me break this one down because we always have questions on it. A counter offer is a purported acceptance. That means the offeree is claiming to accept, but he now changes the terms of the offer because the law says that an acceptance must be unconditional. That's why if you look at the second line, conditional acceptance is in your book. A conditional acceptance is not valid. And I always say this, there are some words in English language, if, provided, subject to, they are imposing conditions. I will buy the car if you bring it to my house. That is not an acceptance. I will buy provided you change the tire. Is not an acceptance. Because these ones are conditional acceptance. The moment a condition is imposed, the acceptance is not valid. But the first one I'm discussing is a counteroffer. A counteroffer is where the offeree imposes new terms that is not in the original offer. I will sell the car to you for 1 million. I say I will buy, but I'll pay 900,000. That's a counteroffer. And what the counteroffer does is that it destroys the first offer. But a counteroffer also becomes a new offer on its own. Now, let me illustrate this aptly. Mr. A goes to B and tells B, I will give you my car for 1 million naira. That's an offer. B replies, I will buy, but I'll pay 900,000. That's a counteroffer. Now, the effect of what B said is that the offer of 1 million naira has been destroyed, terminated. So that if A says, sorry, I'm not selling for 900, and B says, okay, I'll pay the 1 million naira, A will say, I'm not selling again, because that offer of 1 million naira is no longer in existence. It has been terminated. But every counter offer is also a new offer on its own. That means B, the offeree, now becomes the offeror as far as the 900,000 is concerned. So that A can now say, 900, bring money. At that point in time, an agreement arises between them because B's counteroffer of 900,000 becomes a new offer on its own, which is capable of being accepted by A. So what it does is that a counteroffer changes the position of the parties. The initial offer now becomes the offer of the counteroffer. But note that if the initial offer does not agree to the counteroffer, that original offer is no longer in existence. You cannot go back to it again. That's the effect of a counter offer. That is for counter offer. Then communication of acceptance. The law says that an acceptance must be communicated. That means the offeree must communicate the acceptance to the offeror. Initially, I mentioned it that the offer must be communicated to the offeree. So you are going to see that what you call the offer and the acceptance are like two lines. See, two-way traffic. The offer must move from the offeror to the offeree. And the acceptance must also move from the offeree to the offeror. That's why if you look at your pack, the rule is that silence does not constitute an acceptance. But the acceptance can be done orally, in writing, or by conduct, just like we started with the offer. It can be done orally, in writing, or by conduct. We're going to see this. Every offer, right, must get to the offeree for it to be valid, and the acceptance must also get to the offeror to be valid. If you now look at the last one, posted acceptance, that is one exception to that rule. The rule is that if the parties, the offeror and the offeree, have agreed, either expressly or by implication, I will explain what that means, that the acceptance should be posted. That's a letter of acceptance should be posted from the offeree to the offeror. A letter of acceptance becomes effective at the moment it is posted, not when it's actually delivered. That is the only exception to the rule, that acceptance must get to the offeror before it becomes effective. If the offeror has agreed with the offeree that the offeree should post the letter of acceptance, it is the moment the offeree posts the letter, drops it in the post office, that it becomes effective. That's a binding acceptance at that point in time, not when it is actually delivered to the offeror. So by implication, if you look at your material, you have the case that illustrates that. That shows that a letter of acceptance becomes effective when posted and not when it is delivered. We call the rule in Adams and Linsell. And in your material, you have the case of household fire insurance and grants, in which case the letter was posted, but it was lost. It was never delivered to the offeror. The court still held as a valid contract, because the rule of acceptance by post is that there's a valid agreement from the time the letter of acceptance is posted and not when it's actually delivered. So that even where it's never delivered at all, there's still a binding contract. So that's the rule as far as acceptance is concerned. And like I said when I started, when we say a contract is an agreement, the components of the agreement are offer plus acceptance. O plus A is equals to agreement. So that once we say A and B has agreed, what it simply means that an offer has been made and accepted. Get that? Because you are likely to come across some questions that will say there was an agreement. Once it says in the question that there was an agreement, it means the offer has been made and it has been accepted. But note what constitutes an offer and note what constitutes an acceptance. So that is for the first one. Now let's go to the third component, which is consideration. This is the most important requirement when it comes to enforceability of a contract, because the law says that unless the contract is one made under seal, that means like landed documents relating to land and so on and so forth, where there's a seal, that's signed, sealed, and delivered. only a person who has furnished consideration can enforce a contract. Once the contract is under seal, consideration is the most important thing. That's why I started by saying that every contract is an agreement, but not every agreement is a contract. So that even if an offer is made and it is accepted, it doesn't mean there's a contract yet. The next question the court will ask is, has consideration been furnished? Now, what is consideration? We're going to see that consideration was defined in the case of Curie and Misa. I say it's very long, but that statement says that consideration may consist of either a right, interest, profit, or benefit accruing to one party, or a forbearance, detriment, loss, or responsibility given, suffered, or undertaken. I always break it down that way, but I'll say it this way now. In simple layman's term, I define consideration as a price. You know when you use the word price, P-R-I-C-E. We all understand what that means. Paid by a person for the promise made by the other party. That means before you can enforce a promise made to you by someone, you must show the court that you have paid a price for that promise. It is only if that price has been paid that the court will now compel that person to fulfill the promise made to you. Now, let me practically explain this to you. If you look at what you have been discussing, A goes to B and tells B, I will give you my car if you give me 1 million naira. If we look at that, A just made a promise to B in respect of his car. But like I told you, that promise requires B to do something in return. That's to pay 1 million naira. That is the offer. We have discussed that. Now, supposing B replies, I will give you 1 million naira for your car. We have discussed that as well. That shows us that at that point in time, B has accepted the offer. We now said from what we have discussed before that the parties have agreed. But if we break it down to its component part, A has made one promise to B. B has also made another promise to A. If you look at it very well, that means at that point in time, the two parties have made promises to one another. A's promise is in respect of the car, while B's promise is in respect of the money. Now, if A gives the car to B and B fails to give him the money, A will now have the right to go to court and sue B. This man promised to give me 1 million naira. I want you to compel him to pay. The court will ask A, what price did you pay for that promise? What have you given him in return? He will say, I gave him my car. That is the price he has paid. On the other hand, if it was B who paid 1 million naira to A and A fails to give him the car, B will be able to go to court and sue A. This man promised to give me his car and I want you to compel him. The court will always ask him, what did you give him in return? You say, I gave him 1 million naira. That's the price he has paid. So if you look at it, consideration is simply the price you have given to the other party to enable you to enforce the promise made to you. Listen carefully. We're going to see that there's no topic in our syllabus here that is enforceable as a contract unless you have given something in return. We are going to deal with company law. If you apply for shares in a company, right, no matter what happens, you'll be surprised that there are times when if you even get the shares that are not fully paid, you must still have paid a part of the money, because we're going to look at that later. You must have paid something no matter how small. That's why consideration is very important. If you have not paid any money, the company will not recognize you as a shareholder. But if the shares are partially paid up, you are still a shareholder to the amount you have paid up as far as that share is concerned. We're coming to that. But the definition here is wide. But you know, if you look at the definition in Curia Misa, it says it is a right, interest, or profit accruing to one party, or a loss, detriment, or forbearance suffered by another. If you look at the example I gave you, by the time A gave his car to B, B has obtained a benefit, A has suffered a loss. If it is B that gave the 1 million naira to A has obtained a benefit, while B has suffered a loss. But the peculiarity of that definition is that the two sides may not be present at the same time. It may be either of the two. What you have done may either be a material benefit, money, or even a promise. Because I always say this, consideration is not only about money. It may be an act you have done, maybe a promise you have given, or a material benefit. We're going to look at that later. Now, let's go ahead. We have some rules that deal with consideration. One, consideration must have some value, but need not be adequate. If you look at the book, it says consideration must be sufficient, but need not be adequate. Sufficiency means that whatever you have done must have some value, must be of some value in the eyes of the law. I'll repeat that again. In the eyes of the law, not necessarily in the eyes of the other party. To the other party, it may be worthless. But provided the law can quantify it to be worth something, then that is what we call sufficiency. I'll give an example. Somebody comes and says, I'll give you my car if you give me 500 naira. Naturally, a car is worth far more than 500 naira. But the law says that it is what he asks for in return. If you give him the 500 naira and he fails to give you the car, you sue him. And he goes to court and says, my Lord, how can I give a car for 500 naira? The question is, what did you ask for in return? And what did he give you? Say 500 naira. In the eyes of the law, the 500 naira has value. I always use for this purpose promotional adverts. Bring in a wrapper of Tom Tom, 5 wrappers of Tom Tom, and collect a brand new television. You cannot compare the value of the two. That's why the law is not interested in adequacy. We said consideration need not be adequate. That means it need not be commensurate. Provided in the eyes of the law, it has value. The person that will win that color television might not even have bought anything. It might possibly have ended up picking up the wrappers from the gutter. But as far as the law is concerned, he has still given something. To Cadbury Sweets, those wrappers are useless. It is to be dumped. But the person that supplied it has given something as far as the law is concerned. That's why we say that consideration must be sufficient. We're going to deal with this later because we're going to see that the question the court will say, have you given something? Provided what you have given has some value, that's what we call adequacy, or it is, but it need not be sufficient. We're going to see so many examples of this as we move along. 2, consideration must move from the promisee. That means only a person who has furnished consideration can sue. If you have not given something in return, you cannot sue. So if I promise you my car and you have not paid me, you cannot sue me successfully. But note this, the law does not say from the promisee to the promisor. That means the person who made the promise to you may not even have enjoyed the benefit of what you have done. If I come to you and say, I'll give you my car, if you give my junior brother 1 million naira, you are not paying that money to me. The beneficiary of the money is my junior brother. But I've made the promise to you. You are the promisee. If you pay that money to my junior brother and I fail to give you my car, you will sue me. Because I'm the one that made the offer to you. My argument is that, but you didn't give me the money. I didn't enjoy the benefit. But you has given something in return. That means consideration has moved from you. The meaning of that is that only a party who has furnished consideration has the right to sue. We're coming back to that when we're dealing with privity of contracts. Then the third one is that consideration may be executed or executory. I like laying emphasis on this. Executed means it is something that has already been done. Executory means it is something that is to be done in future. That means it is comprised only of a promise. Here, I will allow the class to participate. Now, I always say this. The most common contract almost every one of us is involved in or has been involved in is what we call employment contracts. I want to believe that. Now, that is the relationship between the employer and the employee. I want to ask this question, and I want people to answer me. What is the consideration furnished by an employer to the employee under a contract of employment? And what is the consideration furnished by the employee to the employer? Yes, let's take that. Let me have answers to that. What consideration does an employer furnish to the employee in a contract of employment? And what consideration does the employee furnish to the employer? Yes, who wants to answer my question?
Hello. My name is
Hello? Hello?
Hello, sir. Can you hear me?
Yes, I can hear you now.
Okay. So let me attempt that. The consideration.
Yes, I'm listening.
Yes, the consideration that's the price paid by the employer to the employee is the salary and the benefits agreed.
Salary, yes, let's just say salary. What about the employee to the employer?
The duties and the responsibilities they are meant
or
to handle.
Let's just call it services.
Services, yes.
Is that not what you do? You render services. Okay, fine. Any other answer? Any other person wants to answer? Is that the answer we all agree to?
Yes.
Okay, fine. Let me now.
It's my own salary from the employer.
From the employer.
And services.
Okay.
From the employee.
Fine. Okay. Let me now surprise you that the answers are wrong.
I want to add something, sir.
Yes.
Yes, sir. Good evening, sir. So the constitution
I'm listening.
is an executory one.
Yes.
Thank you, sir.
Executory one. No, don't let us even call it executory or executory. What I'm saying is that I said constitution, you know what we're discussing, that constitution may be executed or executory. That's what we're discussing. And I say executed is something you have done, while executory is something you have agreed to do, but not done yet. Do you know that in a contract of employment, what the employer gives to the employee is not salary? It is a promise to pay salary. Sit back and think of that. Do you know your salary is paid at the end of the month, but you work throughout the month because your employer has promised to pay? Is that not so? Not because he has paid you. That means that the consideration is executory. On the other hand, in most public service especially, the employee is being paid a salary not for working but for promising to work. You see, at times when I teach a class like this, I always ask people, but I don't want to waste time. Those of you who are football fans, you know your teams now, and you know the number of players on some of your teams that have not played this season at all, but they are still collecting their salary. They are collecting their salary because of what they promised to pay. But let's come back home. Do you know if you buy goods from a seller, you are supposed to pay the price? Is that not so? Hello?
Yes, sir.
Yes, sir. We are with you, sir.
Yes, sir. We can hear you. Go ahead,
what
sir.
happens where you buy it on credit? What do you give to the seller?
A promise not.
Promise to pay.
Thank you very much.
Promise to pay, yes, sir.
A promise to pay. Do you know that if what is supplied to you is defective, you can still sue him? You have not paid.
Yes, sir.
But if you sue him, you say, but I promise to pay. That is to show you that it is not, you know why I lay emphasis on this, please? We're going to see some questions in the exam. It is not only where you have paid for something that you have furnished consideration. A promise to pay is also consideration. You know why it is? Let me take you back to the last slide again. If you look at the definition in Curia and Misa, it says, a valuable consideration in the eyes of the law may consist either in some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss, or responsibility given so far undertaken by the other. Thus, consideration does not consist of profit by one party, but also exists where the other party abandons some legal rights in the present or limits its legal freedom of action in the future as an inducement of the promise of the first. You can see promise of the first. That means that, look, you go to work throughout the month because the other party has promised to pay. That's why if you don't go to work, your employer can query you. He has not paid you, but he has promised to pay. So that is why I always lay emphasis on this. Consideration may be something you have done or something you promised to do. That's the meaning of consideration may be executed or executory, but must not be passed. Now, let's quickly look at this. But it must not be passed. The law says that a past consideration is something that has already been done before the promise you want to enforce is made to you. Now, let me just give you a small illustration to explain this clearly. Supposing you are driving along the road on a Sunday evening and the road is deserted. All of a sudden, your vehicle breaks down and all efforts to make it move failed. And you know the area where you are is not too safe. So you just have to move it from that place. And you are aware of the fact that further down the road, there's a filling station not too far away. At least over there, it will be safe overnight until you get your mechanic to repair it. Eventually, somebody stops for you when he knows it's getting dark. What's the problem? Say, look, thank God. Please, I just want you to help me tow my vehicle to that filling station there, about half a kilometer away, so that it will not be vandalized there overnight. And the person says, no problem. He brings out the tow rope, ties it to your car, and tows your car to the filling station. When you get there, you were seriously relieved. You thank him, you get his name, number, say, look, you have saved me a lot of money. And for what you have done, I'll give you 50,000 naira. It's more than I will have lost. I say, look, I don't have money here, but just let me have your details. I'll send the money to you. You have promised him 50,000 naira because he has towed your car. Now, supposing you fail to pay the money and he now decides to sue you. This man promised me 50,000 naira. The court will ask him, what did you give in return? You say, I towed his car. But the reality is that he had already towed the car before you made the promise to him. In law, that's a past consideration. And the law is that a past consideration is not a sufficient consideration. You cannot enforce a promise made to you based on something you have already done before the promise was made. It's not as if you didn't do anything. But in law, it qualifies as what? A past consideration. And the law is very clear. A past consideration is not a sufficient consideration. That is one important area. The second one that follows is that consideration must not be illegal. That means what you have done must not be something illegal. Somebody says, look, if you help me beat up some social person, I'll give you 1 million naira. I say, that's my work. After beating me up, he now fails to pay the money. You now sue him. What did you do in return? Say, I beat up social person. What you have done is illegal. The law will never enforce that promise. Because whatever you have done must not be illegal. We are going to see that when we are looking at vitiating elements, illegality affects a contract. It now means that if what has been done is illegal, the law will never enforce an illegality. Let me beat up so, let me kill this, let me smuggle. All those ones are illegal considerations. The law is very clear. Consideration must not be illegal. Then the last one, a promise to perform an existing obligation is not consideration. Yes. That means if you're already bound to do something, either by contract or by the nature of your work, the law says that if the other party now makes a promise to you, let me just give you a very apt illustration of this, not to waste your time. If you take a taxi, say so destination, you give him a destination, it says 5,000 naira, and you climb in and it takes off. At that point in time, you have a contract with the taxi driver. His own duty is to get you to that destination, while yours is to pay 5,000. But supposing after about 30 minutes on the road, you get stuck in serious hold-up, and for 30, 40 minutes, you are on the same spot. You now tell the driver, I say, look, if I don't get to that place in the next 10, 15 minutes, this whole thing is wasted. I say, hey, it's not my fault. You can see traffic everywhere. I say, look, you are a taxi driver. You can find a way for me. Anyway, if you can just get me there and I don't miss my appointment, I'll pay you 2,000 naira extra. He now says, sit down. The next thing he does is that he just notices that the curb where people are walking is free. He just climbs onto the curb. While people are busy shouting, within 2 minutes, he has already gotten out of the traffic. And within the next 10 minutes, he gets you to where you are going. One, he has gotten you there. You get there, you now give him 5,000. I'm sure he will now start arguing. My money is 7,000. How come? He said, you promised me an extra 2,000. Then you ask him for doing what? You say for bringing you here. But the question you ask is, what was he bound to do before? Was he not bound to get you to that place? He has only performed the obligation he's supposed to perform under the agreement. And the rule in law is that by getting you to that place, he has not furnished any consideration. He has not done anything that is other than what he's supposed to do. That's what that one means. That a promise to perform an existing obligation or the performance of that obligation is not a sufficient consideration. So that's all we need to know as far as consideration is concerned. Note what I said before. Consideration is a price you have given to the other party. But the price may either be a promise in return for another promise. It may be a material benefit. It may be in terms of money. It may be an act and so on, or even a forbearance. But the rule is that, one, it must have some value. That means it must be sufficient, but it not be adequate. Two, it must move from the promisee. And three, which is very important, it may be something you have done that's executed, or it may be executory. Consideration is a very important requirement for the enforcement of a contract. Now, that's the third requirement. Let's quickly look at the fourth and the last one. They are very minor ones, but they are still okay. Intention to create legal relations. Intention to create legal relations means that the parties to the agreement must have intended that the agreement between them should be legally enforceable. That means they will have the right to go to court and sue one another. And how to determine this is very simple, because you find out that, I've said it before, the law does not say a contract must be in writing. In practice, 99.9% of contracts are never in writing. But even the ones in writing, you hardly see people put it there that I have a right to sue you or I don't have a right to sue. But the law says that to determine if parties intend to create legal relations or not, what the law does is to divide all agreements, whether it is oral, in writing, or by conduct, it doesn't matter, into two basic categories. One, social or domestic agreements, and two, commercial agreements. Social or domestic agreements simply refers to agreements between members of family, husband and wife, parents and children, siblings, that's brothers, sisters, and so on and so forth, or purely within a social setting amongst friends. The law is that in such a situation, it doesn't matter whether there's a written agreement or not. There is no intention that the parties will go to court and sue. If there's a dispute, you have to resolve it amicably. If you go to court, the court will say no. such agreements are not legally enforceable. If you look at your material, you see the case of Balfour and Balfour. You see merit and merit, Spellman and Spellman. There are so many cases there. Jones and Privity. There are cases between husband and wife, brothers and sisters, mother and daughter, and so on and so forth. In all the cases, the court held that the parties cannot sue because the presumption in law is that there's no intention to create legal relations. The only exception to that is the case of McGregor and McGregor. We're going to see it in the back. In that case there, at the time of the agreement, the parties' marital harmony has been destroyed. They were about to divorce when they enter into the agreement. The court held that that's the only exception to the rule. That's why divorces are recognized by law, so that such agreements related to divorces can be enforced. The rule in law is that if the parties are still within that marital harmony, or they have that domestic harmony at the time of the agreement, it doesn't matter whether it's in writing or not. If you look at the case of Balfour and Balfour, there was written agreement between husband and wife. The court held that it is not enforceable because it's still a domestic agreement. On the other hand, in McGregor and McGregor, the husband and wife were about to divorce when they signed the agreement. The husband now refused to fulfill it, but the court held that he must fulfill it because at the time of that agreement, the domestic harmony between them does no longer exist. That's the only exception to the rule. On the other hand, when it comes to commercial transactions, provided the parties are not in a domestic relationship, then once it involves any commercial interest, the law presumes that the parties have a right to sue. You have a right to enforce it. That's why it is presumed that there's an intention to create legal relations. That's why I said that this one is very simple and straightforward. What you simply ask is this: what's the nature of the agreement? Is it a domestic or social agreement? That's why if you see a question that says they are husband and wife, they are parents and children, mother and daughter, the law says such agreements are never enforceable. But if it says that the relationship between them, it does not mention relationship between them. It just says that A promised to pay B, C, and D. It is always presumed to be a commercial transaction, and all commercial transactions are legally enforceable. That means there's an intention, as far as the law is concerned, to actually create legal relations. That's for that requirement. Then the last one is capacity. When we talk of contracts, we look at the persons involved. Then here, which is very important for our syllabus here, the word person here does not mean natural human beings alone. Because we're going to see, especially when we deal with company law, that a person may be an artificial person. Because a company is an artificial person, a corporate person. That's why we use the word corporate personality. Now, when we deal with contracts, the law says that if the person is not a natural human being, he has capacity. Every corporate person has capacity to enter into contracts, unless his materials or documents of registration says he cannot do certain things. But on the other hand, when it comes to natural human beings, there are two categories of persons that have limited capacity to enter into contracts. These are infants. Infants is anybody below the age of 18 years. Under the law, an infant has no contractual capacity. That means he cannot enter into valid, enforceable contracts. The position is that you cannot sue the infant, but the infant can sue you. That's the problem with that position. If an infant enters into a transaction with you, you will not be able to sue him, but he has the right to sue you if he's agreed with what you have done. That's why at the point in time when people were now refusing to enter into contracts with infants, the law now recognizes that the only type of contract an infant can enter into validly and is enforceable against the infant is a contract for the supply of necessaries. Please, this word is not necessity. It is necessaries. That's the word. You see it in the pack. Necessaries are defined as goods or services which an infant actually requires to sustain his existence, depending on the infant's status in life. Now, let me break this one down. That means we're looking at what the infant needs to survive. Food, shelter, clothing is always the basic necessity of life. But it must be something that the status of the infant in life can accommodate. If the status of the infant in life cannot accommodate it, that means look at his background and so on and so forth. If it is too exorbitant for him, even if it is food, shelter, clothing, the court will not enforce it because it will not be recognized as necessaries. But note one thing, educational services and contracts of apprenticeship has now been recognized as necessaries for an infant, because even an infant still needs to get educated. Even if he doesn't go to school, he can learn a trade that will be used to benefit him later in life. That's why the law says that these are basically, if you look at your park, you are going to see a case there, Nash and Inman, where a 17-year-old undergraduate went to a fashion designer and ordered 11 waistcoats of different colors. The court held that despite the fact that it is clothing, it is too exorbitant for his status in life. So it does not qualify as necessaries. So the only type of contract that can be enforced against and by an infant is contracts for the supply of necessaries. And necessaries are what he needs to survive depending on his status in life. You see all these ones in the pack. The second one, I don't like wasting time on it, is insane persons. The law says that an insane person lacks contractual capacity. As far as law is concerned, once a person is certified insane medically or legally, then he has no capacity. Although you're going to see that under the law, some insane people have lucid interval. The law says where such a person enters in a contract during lucid interval, where he appears to be normal, you may be able to enforce it. The word is may, provided he's fully cured and he recollects entering into the contract. That's why it's as good as saying that a contract with an insane person is not enforceable because they have limited capacity. The only time they can enter into contract and you may be able to enforce it is if it is done during a lucid interval. But besides that, every other person is presumed to have capacity. In the past, there used to be an issue about the capacity of married women, but that one has been taken away as far as the law is concerned. So that is for the 5 requirements of a valid contract. I'll take them again: offer, acceptance, consideration, intention to create legal relations, and capacity of the parties. So those are the 5. And like I said when I started, they are mutually exclusive. If any one of them is missing, that's why even if everything is there and the person is an infant and is not for necessaries, it is not enforceable as far as the law is concerned. If the person is insane, it's not enforceable. Or if the parties are in a domestic relationship, then it's not enforceable because there's no intention to create legal relations. Those are the 5 requirements of a valid contract. Now, let's quickly look at privity of contracts. This is a fundamental principle. We're coming back to it later because it is actually a topic that introduces some of the topics we have there. The rule of privity says that only parties to the agreement can sue or be sued. That's the rule later in the case of Dunlop and Selfridges. Only parties to an agreement can sue in respect of it and can be sued. That means a third party, even if it's not, if it's a beneficiary, cannot sue and be sued. You know, I gave an example earlier on. I said, I'll give you my car if you pay my junior brother 1 million naira. And you gave the money to my junior brother. Under the law, the agreement is between me and you. By implication, you cannot sue my junior brother, and my junior brother cannot sue, because my junior brother is a third party as far as the agreement is concerned. The funniest thing is that, supposing I give you the car, and you didn't pay the money to my junior brother cannot sue you. I'm the only one that can sue, because only parties to a contract has the right to sue or be sued. That's what we call the doctrine of privity of contracts. A third party cannot sue, neither can a third party be sued. But there are some exceptions where a third party can sue and be sued. And these exceptions that applies to our syllabus are: one, the law of trust, which we are going to discuss later, and agency, which is a core part of our syllabus. But the third one we have here is insurance. Most of us know of third-party insurance. In a third-party insurance, if you insure a car with an insurer, if you are involved in an accident with a third party, the insurer's obligation is to compensate the third party and not you. That means it's only that third party that can enforce that contract. That's why that one is an exception as far as that doctrine is concerned. But that one does not fall within the ambit of our syllabus. We are going to deal in total with agency and the law of trust. And for that, I will still bring you back to the doctrine of privity of contracts. But it is very pertinent to almost every part of our syllabus, because when we are looking at contracts, the general rule across is that only parties to the agreement has the right to sue and can be sued, except it falls under the recognized exceptions. And the two we're interested in, I'll repeat again, is agency and the law of trust. So that's for privity of contracts. Let's look at terms of a contract. When we discuss terms, what we're saying here is that what exactly have the parties agreed upon? How do we know? You see, the reason for that is that when people are entering into agreement, a judge is never there. But if there's a dispute, it is still the judge that will now say, no, from my own view, this is what you have agreed, this is what you must do, this is what you cannot do. It now means that we must be able to determine exactly what the courts will enforce. You know, we described a contract as an agreement that can be legally enforced. Now, the terms of a contract are divided broadly into what we call express terms and implied terms. Express terms and implied terms. Express terms are those terms that the parties have agreed upon between them, orally or in writing. You know, if the law says contracts must be in writing, it will save a lot of problems. If there's a dispute, you bring out the written document. But the law does not define a contract as a written agreement. We said that can be made oral. In writing. Hello, please, can you mute your mic, please?
Now that you are one of the leading sources of food.
Hello.
Nigeria.
Anyway, so like I was saying, we have express terms and we have implied terms. Express terms are those that the parties have agreed orally or in writing. So if there's a dispute, it's always easy to bring out such a document. Or if there's a dispute about oral terms, you can always adduce evidence as to what you have agreed. But the law recognizes that there are some times when you enter into contracts without even uttering a single word by your conduct. But the law will be able to say this is what you are presumed to have agreed upon. Or at times, even where there are written agreements, there are some with the law will on its own read into the agreement to enable that agreement make sense, what we call business sense, or give it a business efficacy. These are what we refer to as implied terms. These are terms that the parties have not expressly, either orally or in writing, mentioned, but the law on its own will read into the agreement. And this one is normally done either by making reference to a custom that applies to that particular contract, or at times a written law, what we call statutes. You see examples in your textbook, but I'll give you a few examples now. If you look at employment contracts, which I always use, the law does not say it must be in writing. But supposing you employ two people, one male, the other female, and you give them written particulars of the contract. If you read through those written particulars, it will contain their names, maybe the job description, and so on and so forth. And if the two of them are of the same cadre, you'll be surprised that the letters you give them will be the same. The only difference will be their names. Every other thing will be the same. But you'll be surprised that if after about 2 years, the female employee pushed to bed, she'll be entitled to maternity leave. But the issue of maternity leave will not be in the letter you have issued. But you cannot say because it's not in the letter, she cannot go for maternity leave, because that is the tradition, is a custom as far as employment is concerned, that a married woman who pushed to bed, right, a woman who pushed to bed is entitled to maternity leave. So if you now refuse and she goes to court and sues you, you cannot say, my lord, look at the written agreement. It's not there that she can go for maternity leave. The court on its own will read it into the agreement. That's what we refer to as implied term. Oftentimes, if you take a boss, it's implied that you must pay, provided you know the amount. So you don't need to tell the conductor, I will pay you. It's implied that you must pay. If you now drop and you are going away, and conductor says money, and you say, now, did I agree to pay you? You don't need to have agreed expressly. But by entering into the bus, it is implied by law that you have also agreed to pay. That's why the conductor has the right to sue you and demand this money from you. So when we want to enforce a contract, the law says that the terms the court will enforce is not only about what the parties have expressly agreed upon, but it also includes what the law on its own will read into the agreement, what we call implied terms. But before we go away from terms now, we're going to see that all terms, whether written, oral, or by conduct, is now divided into two again. You see this in the back. We call it conditions and warranties. A condition is said to be a fundamental term that goes to the root of the agreement, while a warranty is a minor term that does not go to the root. I will explain what I mean by that. If there's a breach of a condition, the contract can be terminated by the aggrieved party. It can insist that I'm not going ahead. That means it repudiates. We call it repudiation. The aggrieved party can repudiate the contract or sue for damages, can claim a sum of money for a breach of contract. We call it damages. But if there's a breach of a warranty, the aggrieved party cannot repudiate. The only remedy is to sue and claim damages. That is sum of money. Now, let me explain what we mean by this. If we use a big tree to illustrate a contract, let's picture a big tree. You are going to see that what we see over the ground will be the trunks, we see the branches and the leaves. But the most fundamental part of that tree is the part that is underground, the roots. If anybody, without touching the trunks or the top part of the tree above ground, manages to go underground and cuts it off where the root starts, that tree will automatically die. That is why we compare what I call conditions to the roots. That will say it goes to the root of the agreement. It's so fundamental that without it, the contract can no longer remain in existence. That's why if there's a breach, the other party can say, no, I'm no longer interested. If somebody comes to you and says, I'll sell my car to you for 1 million naira, and you agree, by the next day, you get to learn that he stole the car. That means not the owner. I'm very sure you simply call and say, I'm no longer interested in the car. And definitely cannot even sue you to come and pay. And if you have already paid him, you will compel him to pay your money back. So you are going to see that that's why we compare. Condition is a fundamental term. It forms the root or basis of the agreement so that if there's a breach, it is capable of bringing the contract to an end. So that the other party can say, no, I'm no longer going ahead. Or in the alternative, will have the right to sue and claim damages. On the other hand, we can now compare the branches and the trunk to guarantee. If somebody cuts off the branches of a tree, the tree does not die. It has been affected. That means we now say that there's a breach of the warranty. It has affected the contract, but it's not fundamental because the roots are still there. That same tree will still survive. That's why the law says that where there's a breach of the warranty, you cannot repudiate the contract. You can only sue and claim damages. We are going to see the importance of this later when we're looking at breach of contract. We're coming back to it later. Now, in some contracts, some terms are conditions, while in some contract, it is a warranty. It is the importance the parties attaches to a term that determines whether it's a condition or a warranty. So that is for terms of the contract. Now let's quickly look at vitiating elements. The word vitiate means to spoil. That means something that we picture as being very nice. Something is now introduced that spoils the whole thing. Let me explain what we mean by this. You are going to see that we have already mentioned the fact that where you have 5 things together, what you have is a contract. That is, we are talking of offer, acceptance, consideration, intention, and capacity. Once the 5 are together, we have a valid contract. But the law says that there are some elements that may be introduced into the picture that will now spoil everything, so that the court will say, no, this contract is not valid, despite the fact that all the 5 requirements are present. Take that again. That means what we call a vitiating element is a factor that destroys an otherwise valid contract, so that the court will be able to say this contract is void or voidable. We're going to see it in the pack. When you say it's void, the word void means that there's nothing there. There's nothing to enforce, or that a party has the right to say, no, I'm no longer interested. But when we say there's a vitiating element, for our syllabus, we're going to look at 2: mistakes and misrepresentation. But another one in the pack, which is not too pertinent to our syllabus, is duress and undue influence. Somebody puts a gun to your head and says, you sign this agreement, and you sign. You see, under the law, you are bound by content of what you have signed. But you can go to court and say, my lord, it's not binding on me because I entered into this agreement under duress. If you look at that situation, you'll be surprised that there will be offer, acceptance, consideration, everything. But the court will still not enforce that agreement because of a vitiating factor. I just mentioned duress. But the ones that are pertinent to our syllabus are mistakes and misrepresentation. Now, let's quickly look at mistakes. Mistakes arises where one of the parties or the 2, because I'm going to say that we have 3 types of mistake. One of them or the 2 of them enters into the agreement under the impression that a particular fact exists, but unknown to them or known to him, that fact does not exist. I'll take it again. Where one or the 2 parties enters into the agreement under an impression that a particular fact exists, but unknown to him or known to them, that fact does not exist. They are said to have entered into the contract under a mistake. Now, let me give you an illustration that will clearly explain what I've just said. We have 2 friends, A and B. They have been friends since their school days. They graduated the same year. And coincidentally, they work in the same organization, but in 2 different offices. A owns a car. B, the friend, has made use of the car a few times in the past because they are that close. On this particular day, at 10 a.m. in the morning, look at the time I mentioned, 10 a.m. A went to B, his friend, and said, oh boy, I want to inform you, I intend to sell my car. Since you are my best friend, I'll give it to you for 1 million naira. So if you are interested, let me know before I offer it to somebody else. B immediately accepted the offer. I said, oh boy, thank you, I'll buy. In actual fact, he brought out his check and quickly wrote a check for the sum of 1 million naira in A's name. I said, yeah, take. Here's your payment. Oh, yeah, bring everything. Don't even bother. A now said, look, you have to wait until 12. Because by 8 a.m., I called my mechanic to come and carry the car and change the fuel filters. And I'm very sure that latest by 12, he will return the car. Meanwhile, B also knows the mechanic. I say, okay, if he does one, no problem now. Once he brings the car, but you know what? Bring the particulars. Oh yeah, sign receipts. So the only thing you hand over to me is just the key. So that everything will be taken care of. And A says, no problem. At 10 a.m., he signs all the documents, gives the original particulars to B, and goes back to his office. You know, they have concluded that contract in respect of that car at 10. But the issue is that what happens if, unknown to the two of them, at 9 a.m., that's 1 hour after the mechanic came to pick the car, that car has been destroyed by fire in the mechanic's workshop. It has been burnt beyond repairs. Now, let me take you back to what I just showed you. The agreement between A and B in respect of the car was entered into and concluded at 10 a.m. But unknown to the two of them, at 9 a.m., 1 hour before, that car has been burnt beyond repairs. Don't forget that it means that at 10 a.m., both A and B believed the car was in existence. And that was the reason why that contract came into existence. As far as law is concerned, the two of them entered into that contract under a mistake because the two of them believed in the same fact that the car was in existence. And it was because of that that they entered into the contract. If you break it down, if either A or B was aware of what happened to that car, it's very obvious that that contract would not have been entered into. That's why the law says that the two parties in that case have entered into the contract under what we call a common mistake. That's why if you look at mistakes, we have common mistakes, mutual mistakes, and unilateral mistakes. What we call common mistake is where the two parties make the same mistake about the subject matter, just like the example I just gave you there. The two parties at 10 a.m. believed the car was in existence. And that was why they entered into the agreement. If you look at your pack, you see the case of Couturier and HT. Something like that happened in Couturier and HT. They both believed that the subject matter was in existence at the time of the agreement. But unknown to them, it has been destroyed before then. But the two parties were acting under the same impression that subject matter was in existence. That's what they call common mistake. Mutual mistake is where the two parties are making mistakes about two different things. That was A is thinking of selling a car. B wants to buy a motorcycle. I'm just using that as an example. And they were busy negotiating. So that at the time of the negotiation, the two of them were thinking of two different things. A wants to sell his Honda, which is a car. B was interested in buying Honda. He's thinking of motorcycle. And they negotiated. It was after they have concluded that B says, what is this? I'm looking for motorcycle. How come you are giving me a car? But all the while they were talking, they have been using the word Honda. Honda, I want to sell my Honda. I like Honda. I want to buy Honda too. That is exactly what we're saying. What they have there is what we call a mutual mistake. That's where the two parties are mistaken about two different things. They were thinking of two different things at the same point in time. If you look at the distinction between common mistakes and mutual mistakes, in common mistakes, the two parties are making the same mistake, thinking of the same thing at the same point in time, and they were mistaken about the same subject matter. But in mutual mistake, they are making mistakes about two different things at the same point in time, so that they ended up in what looked like an agreement. But the law says that if you sit down and look at it, they never really agreed in the first instance. Then the third one, unilateral mistake. That is where only one of the parties is making a mistake and the other party knows. And this one normally deals with signed documents. That is where somebody makes you to sign a document while you believe you are signing a different document entirely. You got it? That is exactly what is happening there. Where a party signs a document. That's why if you look at your fact, we call it non est factum. Non est factum means it is not my deed. You now go to court and say, no, this is not what I believe I was made to sign. This particular one was designed to protect illiterates and handicapped people, blind people. That's why you're going to say it's very peculiar. Where you have a blind man sign a contract, sign a document, and say, look, this document is a rent receipt. We are going to see that here. But what the other party wrote there is that the man who is signing has sold the house to him. You are going to see that the case is about landlord and tenant. The tenant paid rent, and the person that normally uses receipt for the landlord is not around. The tenant said, look, I must take it to work tomorrow, so let me write it for you so you just sign. He now wrote it there that the man has sold the house to him, and the man signed, believing that what he was signing was actually a rent receipt and not a sale receipt. And that man wanted to use it to take the house away from him. In all the cases, you see it in your pack there. The court tells that document, that's why that it was signed, is declared null and void because it falls under what we call non est factum. It is not my deed. That means you are claiming that I'm not saying I did not sign, but this is not what I was made to believe I was signing. Note that for this particular mistake to be pleaded by anybody, you must prove that what you signed is fundamentally different from what you were made to believe you were signing. But two, which is important, is that in signing it, you were not negligent. That's why the average person who is not handicapped can hardly plead non est factum. Especially these days, that we sign a lot of contracts without even reading. The rule in law is that once you sign a contractual document, you are bound by what you have signed. But the essence of this mistake is to protect handicapped persons, blind people, and illiterates. So those are the three types of mistakes we have there. Common mistakes, where the two parties are making the same mistake. Mutual mistake, they are making different mistakes. And the third one is unilateral mistake, where only one party is making the mistake and the other party knows. And often relates to signed documents. That's why we have in the pack what we call non est factum, mistake as to written documents. Then the second type of vitiating element is misrepresentation. Misrepresentation simply applies where a party to the contract, at the time of that contract or before, makes a statement to the other party which induces the other party to enter into the contract, and that statement is false. So what we call misrepresentation is actually false representation. And this one is very pertinent when we're dealing with company law, especially when we're dealing with prospectus. Where a company issues a prospectus, the objective is to lure or convince people to buy shares or apply for shares. The law says that if the statements contained in that document, is a contractual document, is false, and you got to discover it later after you have already applied for and shares have been allotted to you, you can sue for misrepresentation. That's why for misrepresentation to be sued for, you must prove, one, that the statement made must be a statement of fact. That means it must relate to either a fact which had existed before or which was existing at that time. It must not be a statement as to what is to be done in future. That means not a statement of intention or opinion. I'll give an example. A company comes out with a prospectus, offer to the public 1 billion shares of 50 kobo at 10 naira. And it says the company was incorporated in 2020. That's a fact. The company manufactures this and this. That's a fact. The company's profit in 2021, 22, 23, and 24 is this. That's also a statement of fact. If any one of them is false, and you now rely on it and you buy the shares, you can sue for misrepresentation. But if it says that the money to be raised from this issue will be used to build a factory at Agbara to enhance the profit of the company, that's a statement of intention. If they don't do that, you cannot sue for misrepresentation. Misrepresentation must lead to a statement of fact. That's one. Two, it must have been the reason why you entered into the contract. You must prove that it induced you into entering into the contract. And third, it must be false. So those are what we call misrepresentation. Then you are going to see that we have innocent and fraudulent misrepresentation. Fraudulent misrepresentation is you can prove that the person knew that what he was saying was false, or he had no basis to believe in it. But we have what we call innocent misrepresentation. If the person that made the statement himself believed it was true, and I always use prospectus as an example. If the company's director, in their own statement in the prospectus, relies on a statement made by auditors of the company as to profitability, but that statement is false and the directors did not know, then if you are suing the company, you are claiming that the directors made a misrepresentation. But if the directors can prove that they relied on the statement supplied to them by their auditors and they had no cause to know, that one constitutes what we call innocent misrepresentation. Now, the difference between them is for fraudulent misrepresentation, you can sue and claim damages. Not only will you cancel the contract, you also claim damages. But if it's innocent misrepresentation, you can only recover the money you have invested. We call it rescission. We're coming to that later when we're looking at remedies for breach of contract. To resign means that you ask the court to return you to the position you were before you entered into the contract. But we are going to see that misrepresentation can either be fraudulent misrepresentation or innocent misrepresentation. Fraudulent misrepresentation is where the party knowingly made the statement or he made the statement without any basis of believing in its truth. But innocent misrepresentation is where the party himself who made it believed it was the truth. So that's for misrepresentation. Now, let's quickly look at discharge of contracts. That means how can contractual obligations be brought to an end? How is the relationship between the parties brought to an end? We have one, discharge or termination. Please, those two words can be used. The word discharge means terminate, bring to an end. Discharge by agreement. That means the parties can also agree. That one is very simple and straightforward. Every contract is an agreement. By implication, it can also be brought to an end by an agreement. That's number one. Number two is by performance. That's where the parties have performed their obligations fully. That word is important. It is only a full performance that discharges a contract. Under the law, a partial performance does not discharge a contract. If you are supposed to perform 10 obligations and you have performed 9.5, you have not performed as far as the law is concerned. Common law is very rigid. Performance must be full and complete. That's why you're going to see that if somebody agrees to do 1, 2, 3, 4, 5 things and does 4.5, the law says that he does not deserve 1 kobo unless he has completed everything, because the law does not recognize a partial performance. Performance to discharge the contract must be full and complete. Then we have frustration. Frustration arises where something occurs after the agreement has been entered into. And that thing is beyond the control of the parties. It is not due to the fault of the parties, and it makes it impossible for the contract to be performed. Now, 3 things I want you to note here. When we have questions on frustration, 1, the contract must have been entered into, the agreement must have been entered into before the event occurred. 2, what occurred must not be due to the fault of the parties, must be beyond their control. And 3, which is important, the effect is that it makes it impossible for the contract to be performed. Now, let me take you back to an example I gave you earlier on, under mistakes, where the 2 parties agreed at 10 to sell the car, because I'm using past questions here. In this case, the car was destroyed at 9 a.m. and the agreement between them was entered into at 10. And we said that the contract was vitiated by mistake, because if that fact had been known, the contract would never have occurred. But what happens if the agreement was entered into at 10 a.m. and it is agreed that the car will be delivered at 12? But that car was now destroyed by fire in the mechanic's workshop at 11 a.m. That's 1 hour after the agreement was entered into. What that shows you is that 1, the contract already existed. 2, what happened was not due to the fault of either A or B. It was beyond their control. And 3, it made it impossible for the contract to be performed, because there's no way A can hand over the car to B. The contract is said to have been frustrated. That's what we call frustration. That's why when you look at your material, frustrating event includes destruction of the subject matter, cancellation of events if the contract is based on an event, government intervention, like where government goes ahead and takes over a property that you have agreed to buy, and so on and so forth. Especially what happened along the coastal highway, where the government just came and said, look, we have acquired it. We are going to say that so many contracts were frustrated by that event alone, provided 1, the agreement has been entered into, 2, the event that occurred is not due to the fault of either party, and 3, it must have rendered it impossible. The operative word is impossible. If it is still possible to perform, but it's a bit more difficult than before, that's not frustration. Please, you must know this. 3 requirements of frustration to discharge a contract. 1, the contract was entered into. That's why I say there's already a valid agreement. 2, the event occurred without the fault of either party, beyond their control. And 3, it rendered it impossible. Then we say the contract has been frustrated and thereby brought to an end. Destruction of subject matter, outbreak of war, and so on and so forth. If you look at your pack, you see that so many contracts were frustrated by the Nigerian Civil War, especially where one party was in the Biafra side and the other party was in the federal side. So all those things are examples of frustrating events. Then lastly is breach. We often use the word breach. Breach means a break. Breach of contract means a break of your promise. A promise to give B his car for 1 million. B promised to pay 1 million. A gives the car, B fails to pay. He has broken his promise. The word breach means a break. Breach of contract, a break of your promise. But the law says that a breach of contract will only bring a contract to an end if it's a breach of a condition, a fundamental term. If it's a breach of a warranty, it doesn't bring the contract to an end. Only a breach of a condition brings the contract to an end. A breach of warranty will only, you must still continue. You can only sue and claim damages. That is the basic distinction there between condition and warranty, especially when it comes to the issue of breach. That's why I mentioned it before, that is a breach of a condition. The aggrieved party can repudiate, that's cancel it and say, I'm no longer going ahead. That means you can say, I am terminating it. And you can also sue for damages. But if it's a breach of a warranty, you can only sue and claim damages. Now, when we look at breach of contract, we have some remedies. One is damages. That's the only remedy known to common law. Damages is you are claiming a sum of money to compensate you for the loss you have sustained as a result of what the other party has done. Then we have some equitable remedies. Amongst them is specific performance. That's where you go to court and you get an order of the court compelling the other party to perform his obligation, provided you can prove that damages cannot adequately compensate you. That's that remedy. Equity will say, look, you have asked somebody to sell a parcel of land to you, you have paid him, and he refuses to transfer. You can go to court. It's very common in land cases, but court hardly grants it in contract of personal service, especially contract of employment, because the law will not compel a person to retain an employee he does not want. Neither can they compel you to work for somebody you don't want to work for, because it's an order of the court that says you must perform your obligation, whether you like it or not. And it is only granted, note this, where the remedy of damages cannot adequately compensate the party. But note there is an equitable remedy. Then we have injunction. That's an order of the court restraining a party. It is normally done against employers where they want to dismiss the employee and they have not done it yet. They can grant an injunction. Don't do what you want to do, because it will lead to a breach of contract. Then we have what we call rescission. You see this in the pack. Rescission is RESCISSION, rescission. That means an order of the court returning a party to the position it was before he entered into the contract. This normally applies when you look at innocent misrepresentation. That means I've given him 1 million. I want my 1 million naira back. If I paid him 1 million, I can go to court and say I want 5 million. I'm claiming damages. That means a sum of money compensating me for the loss I've sustained. But if I go to court and say I want my money back, that means I want to be returned to the position I was before I enter into the contract. We call this one rescission. It's also an equitable remedy. I want you to note one thing. We are going to see that in your pack, you have 5 remedies: damages, specific performance, injunction, rescission, and contrary merit. Only damages is a common law remedy. All the other remedies are equitable remedies. So that is the foundation of almost everything we want to discuss tomorrow and next tomorrow. That's for the law of contracts. So ladies and gentlemen, any question before we round up for tonight?
Yes, sir. Good evening, sir.
Good evening.
Yes, sir. On the topic of contracts, like the one that you make example of, the ones that if someone is going for maternity leave, that she
I use that to explain, hold on. I use that to explain what I call express and implied terms.
Yes.
You see, what I'm saying is that it is not only what you agree with your employer. Does your letter of employment show that you are entitled to maternity leave?
No.
Fine, but can your employer stop you from going for maternity leave?
No.
No,
but
because if it does, you sue.
Or with that pay?
Forget that one. That's why I said if it's going to be without pay, it's your employer that will put it there. But under the custom, when it comes to contract of employment, a woman who puts to bed is entitled to maternity leave. If it's not going to be without pay, it is your employer that will have put it there in the letter. I hope I'm making some sense. If he does not put it there, then the law will compel him to pay you. I hope it's clear now.
Yes, sir.
Okay, fine. So you know what I'm trying to say is this. It is not only what the parties have discussed that the court will enforce. When we are dealing with agency, you are going to say that an agent may not even negotiate his commission. But if there's a dispute, the court will say, what amount does other agents in that line of business collect? Then that's what the principal must pay. I hope you're getting it now. Let me give you another one. Do you know what you call collective agreements? Like all these agreements by NLC and all these things. It's also binding on your employer as to minimum wage. Are you aware? But it's not in your letter of employment. That's the custom. Because anything negotiated by the labor unions also becomes enforceable by employees. The law will always imply that. That's what we call implied terms. Yes, any other question?
Sorry, sir. On the components of the contract,
The essentials of a valid contract.
So on the one displayed, no, for the components of the contract, that the one you display is 6, but you said there are 5.
No, you are not
the
listening
one that
to
has
me.
offer,
Madam, you are not listening to me.
acceptance.
Hold on, ma. Hold on, ma. I told you that there are 5, and I discussed 5. The last one is privity of contracts, and I discussed it. I said the general principle that covers all contracts. The 5 I mentioned are offer, acceptance, consideration, intention, capacity. But you see, when I start, I always put privity there to always remember to discuss it. Because once there's a contract, the only people that can enforce it are the people who have entered into the agreement. I hope that's clear now. If you go to the park, you are going to see the way it is discussed. You are going to see that it is separated from the essentials of a valid contract. And I did not call it component of a contract, essentials. Because if you say something is essential, that means without it there. If you say components, one of them may be missing and it will still be there. Yes, any other one?
Hello, sir.
Yes, sir.
So thank you very much for the
You're welcome,
training so
sir.
far. Yeah, mine is just on a lighter note. I tried to raise up my hand initially when you were talking about
I was not.
Intention aspect, and then when you talk about the social relationship, those who can sue and the situation that can be sued and not. On a lighter note, I was just wondering that there's this popular discussion in social media about a man who sent money to his girlfriend, and for them to meet, and they couldn't meet and was sued, and the girl was asked to pay. Is that not a social?
One is not, you see, let's be very frank with us, that one is not a domestic agreement.
Okay.
You understand what I'm saying there? Because you see, what they were still doing there is still a contract as far as the law is concerned. As at that time, they are not, right? They are not married. They are not engaged.
Yes, sir. Okay.
In law, it's still a commercial transaction they are doing. So that's why the guy has the right to sue.
Okay, sir. Thank you so much, sir.
Yeah. So I think we'll stop there tonight so that we'll be able to continue tomorrow. Yeah. So
good evening.
Let's call it a night today. By tomorrow, let's start very early by 7 because we still have a lot to do. So I will be able to now by next tomorrow be able to look at a lot of our questions, because we're going to see that what you have discussed tonight will now be the basis of a lot of things we're going to discuss tomorrow and next tomorrow. So good night all. And
hello, sir. Somebody wants to ask a question.
Good night. Thank you.
Hello? Abike,
hello.
want to ask question?
Yes, please.
Yes.
Good evening, sir.
Good evening.
Good evening. Can you hear me?
I can hear you.
Okay, thank you, sir. So on this last part, this remedies for breach, I think I missed this last part. You mentioned damages, specific performance, injunction,
common law remedy. And the last one is not too relevant to your syllabus, is in the pack. That is quantum merits.
Yes. So you mentioned something like equitable remedy.
I said damages is the only common law remedy.
Fine.
All the other remedies, rescission, hold on. All the other remedies, rescission,
okay,
injunction, specific performance, they are all equitable remedies. They are developed by equity. But damages, that's sue for a sum of money, is the only remedy known to common law.
Okay. Thank you, sir. Thank you.
You're welcome.
Sir.
Yeah.
I'm fine.
Yeah.
Thank you very much, sir.
Okay.
Yeah, we really appreciate the delivery of your class today. I hope we all enjoy our class today. So we are continuing tomorrow.
Yes.
I will next tomorrow particular subject. Thank you very much. And now, like as I said at the beginning of our today's class, I may make sure of having a class governor. If you want to be our class governor, you can indicate. If you have someone you feel can do it, you can also nominate someone. You can send a message to me if you want to be our class governor. The job is very simple. It's just to add between the class and the facilitators and the institute. Just like that. It's very simple. So if you are interested, you want to be it, you can nominate yourself, or if you know somebody who can
Is there
nominate.
salary for it?
If you want to be paid, it's just for this period of time. Okay. Thank you very much. Yeah, we'll see tomorrow, 7 p.m. Thank you. Good night.
Okay. Thank you.
Thank
Good
you.
night.
Good night. Good night.
Thank you.
Thank you.
Good morning.